You are 34 years old, and you are sitting in a public defender's office in Baltimore with a stack of case files so thick the binding tape is split. Your client today is a 19-year-old charged with aggravated assault for a fight outside a convenience store. The evidence is thin, the DA is overworked, and the whole thing will probably be pleaded down to a misdemeanor before lunch. This is your life. You earn $61,000 a year. You drive a 2009 Civic with a cracked dashboard. You believe in the system the way a man believes in a leaking roof, not because it works perfectly, but because it is the only roof you have. You have been doing this for 9 years. You are good at it, not brilliant, not celebrated, but methodical and honest, and in this profession, those two qualities are rarer than people think. You know how to read a courtroom. You know how judges make decisions before they announce them. You know which prosecutors cut corners and which ones play it straight. You have built a mental architecture of how power moves through a legal system, and you have done it from the bottom of that system, representing people nobody else wanted to represent. Then, the case lands on your desk. It is not dramatic when it arrives. It is a manila envelope left with the front office receptionist, addressed to you by name with no return address. Inside is a single document, a sworn affidavit signed and notarized from a mid-level city contractor named Gerald Tusk, who claims that Councilman David Raines accepted $340,000 in cash bribes over a period of 4 years in exchange for routing city infrastructure contracts to a shell company. The affidavit is detailed. Dates, amounts, account numbers, the name of a private storage unit in Towson where Tusk says physical documentation is held. You sit with it for a long time. You do not call anyone. You do not file it. You read it 4 times, and on the 4th time, you realize that you recognize 2 of the names buried in the supporting notes. Not Raines, not Tusk, but the 2 attorneys listed as having facilitated the contract transfers. You know one of them. He is a partner at a firm that has contributed heavily to 3 different judicial campaigns in this city. He plays golf with the state's attorney. He is the kind of lawyer who makes problems disappear before they become problems. You make a decision that changes your life, and you make it quietly, the way most life-altering decisions are actually made. Not with fanfare, not with certainty, but with the simple, stubborn conviction that you cannot put the document back in the envelope and pretend you never opened it. You take the affidavit to a federal prosecutor you have crossed paths with before, a woman named Sandra O'Coffer, who works public corruption cases and has a reputation for finishing what she starts. You walk into her office without an appointment. You hand her the envelope. She reads the first page and tells you to close the door. 6 weeks later, Tusk is in protective custody. The storage unit has been accessed under federal warrant, and Councilman Raines is under investigation. The case moves faster than you expected, and then it moves sideways, which you did not expect. 2 of the judges assigned to oversee preliminary motions recuse themselves without explanation. A 3rd accepts a sudden appointment to a federal bench in another district and disappears from the case. The contractor's original attorney is found to have a conflict of interest and withdraws. The case does not collapse, but it bends, visibly, under pressure you cannot see the source of. You can feel the shape of something much larger than one councilman and one contractor. You map it the way you map case strategy, not emotionally, but structurally. Who benefits from delay? Who has reason to protect Raines? Which law firms keep appearing at the edges of public records you are now pulling obsessively? You are not an investigator. You are not a federal agent. You are a public defender who cannot stop reading. O'Coffer calls you 3 months in. She tells you she has been moved off the case, reassigned to financial fraud. She says it with the careful neutrality of someone who is being recorded, or who believes they might be. She tells you that a private organization has been in contact with her office regarding the broader infrastructure of judicial and legislative corruption in this city and several others. She tells you that they asked about you by name. You meet them in a hotel conference room in Washington. There are 4 people at the table. No business cards are exchanged. What you are told over the course of 90 minutes is this: there is a network. It spans 11 states. It involves sitting judges, state legislators, 2 former governors, a current U.S. senator, and an apparatus of corporate, legal, and financial intermediaries that has been in operation, in various forms, for nearly 30 years. The people at this table have been documenting it. They have leverage. What they do not have is someone who can operate inside the legal system, not as an investigator, not as a prosecutor, but as a judicial figure with credibility, access, and the legal standing to make what they know actionable. They are offering you a judgeship, not a real one, not yet. They are offering you the path. They will support your application to a state circuit court seat that is opening in 4 months. They have the relationships to make it happen. Once you're on the bench, you will be positioned. You will have access. You will be, in their words, the point of accountability that this network has never faced. You ask them what they want in return. They tell you they want the same thing you want. You ask them how you know that is true. Nobody answers for a moment, and then one of them slides a folder across the table. Inside is financial records, communications, and photographs that constitute evidence of crimes by people you cannot believe anyone has documented. People whose names appear on public buildings and Senate confirmation hearings. You look at it for a long time. You close the folder. You do not take it with you. You tell them you need 2 weeks. You take 11 days. You do not sleep well for any of them. You think about what you are being asked to become, not just a judge, which would be remarkable enough for a public defender who drives a cracked dashboard Civic, but something more specific and more dangerous. A judge who has been placed deliberately, who holds information as a weapon, who exists at the intersection of legitimate authority and extra-legal accountability. You think about what that makes you. You think about the 19-year-old from the convenience store assault case, and about Tusk in protective custody, and about 3 judges who recused themselves from a straightforward corruption case without explanation. And you decide that the system you believed in, like a leaking roof, needs someone willing to climb up and do something about the leak. You accept. The judgeship takes 8 months to materialize, and in that time you do nothing that would attract attention. You continue your caseload. You file your application. You interview before the Judicial Nominating Commission with precisely calibrated modesty. You are appointed to the circuit court on a Tuesday and sworn in on a Thursday, and the day you put on the robe for the first time, you understand physically, in your chest, that something has permanently ended and something else has begun. The first year on the bench, you do nothing except become a good judge. This is not strategy, or not only strategy, it is necessity. You cannot be useful if you are not credible. You learn the rhythms of the court, the unspoken hierarchies, which clerks know everything and which attorneys carry influence they should not have. You make clean rulings. You are fair and consistent and occasionally brilliant in ways that get noticed. You build a reputation as someone who is difficult to predict and impossible to compromise, and that reputation is both a shield and a long game. In the second year, the first conversation happens. It is not dramatic. You are in your chambers after a hearing on a civil contract dispute, and an attorney named Wallace Pruitt, who you know is connected to the network you are watching, lingers after his co-attorney leaves. He comments on the ruling. He says with the precise indirection of someone who has done this many times before that there are people who appreciate a judge who understands context, who understands that the law is a living instrument and that its interpretation benefits from a broader perspective. He does not finish the sentence. He does not need to. You tell him that you appreciate his confidence in the court and that you look forward to seeing him in the next proceeding. You watch his face process that. He nods and leaves. That night, you document the conversation in a format and a location you established before you were ever sworn in. You have been building files since before the robe, not on your judicial computer, not anywhere connected to the court network. The methodology was designed for you by people who have been doing this longer than you were a lawyer. Encrypted, compartmentalized, cross-referenced. Every approach, every conversation, every procedural irregularity that suggests a case is being steered from outside the courtroom. You are meticulous because you cannot afford to be anything else. If what you are doing ever surfaces without the full weight of the documentation behind it, you become the corrupt judge. That is the knife edge you live on. By your third year, you have documented 11 separate instances of attempted judicial influence across 6 cases. 3 of them involve the same law firm. 2 involve a state legislator whose name you first saw in Tusk's original affidavit 3 years ago, in a world that feels like another person's life. You are building a picture that is becoming undeniable, and you are doing it from inside the machine that is trying to maintain itself. Then, a case comes to your courtroom that changes the tempo of everything. The defendant is a former deputy mayor named Curtis Leyland, charged with wire fraud and obstruction of justice in connection with a city pension fund diversion that cost retirees $11 million. The case should be straightforward. The evidence is substantial. The prosecution is competent, but the case has been bounced between courtrooms for 14 months before it lands with you, and you understand immediately why.
Every judge it was assigned to found a reason to delay, recuse, or complicate. It arrives in your court because whoever is running interference has run out of options, or because someone made a calculation that you are manageable. You are not manageable, but you let them believe you might be, because the belief is more useful than the correction. Within 2 weeks, 3 separate approaches are made. The first is Pruitt again, this time more direct, more specific, suggesting that a ruling on a preliminary evidentiary motion could be guided in a direction that would serve a broader interest. The second is a phone call to a number only a handful of people have, from a voice you do not recognize, which offers you a figure, $400,000, structured as a legal consulting arrangement through a firm in Delaware, in exchange for a mistrial ruling. You document both. The third approach is different. It is not an offer. It is a warning. Somebody leaves a photograph on your car, in the secure parking structure of the courthouse, of your younger sister leaving her apartment in Chicago. No note, no words. Just the photograph. You sit in your chambers for 40 minutes after finding it. You are not a person who frightens easily, but fear and calculation are not the same thing, and you spend those 40 minutes calculating. You think about what you are holding, what it is worth, what it would mean to back down here, and what it would mean to press forward. You think about $11 million taken from people who worked their entire lives and trusted a system that stole from them. You think about the photograph on your car and what it represents. Not just a threat to your sister, but a message about the limits of what you can do and what they believe those limits are. You call the people who placed you. You tell them about the photograph. You tell them you are accelerating the timeline. If you are going to be exposed, you would rather be exposed on your terms, with the full documentation available, and be ground down slowly by a machine that is now aware you are a problem. They tell you to give them 72 hours. In those 72 hours, the case against Leyland runs. You make your rulings cleanly and on the record. You admit the evidence. You manage the proceedings with the kind of precision that leaves no procedural daylight for appeal. Leyland's attorneys are skilled, expensive, and operating with instructions from people who expected this courtroom to bend. It does not bend. On the 3rd day of testimony, one of Leyland's co-defendants makes a plea deal with the prosecution that includes cooperation. The case does not fall apart. It compounds. The verdict comes back guilty on 7 counts. The sentencing hearing is set for 60 days out, and in those 60 days, the cooperation from the plea deal begins producing names. Not just Leyland's network, wider, the kind of names that make prosecutors go quiet and start working weekends. You are not untouched by any of this. There are 4 separate complaints filed against you with the Judicial Conduct Commission in the 3 months following the verdict. Anonymous, procedural, the kind of complaints that are designed to create noise and consume time and plant seeds of doubt. You respond to each of them through your attorney with the same methodical documentation you've applied to everything else. None of them go anywhere, but they are a message, and you receive it. You are known now. You are not anonymous anymore. This is the reality of the role you have built. You are not anonymous. You are not untouchable. What you are is documented, positioned, and too deep inside the architecture of what is being built to be removed without cost. The people who want you gone would have to expose enough of what they have done to remove you, and that calculation, for now, keeps you standing. There are now 3 federal investigations open that trace directly or indirectly to documentation that originated with you. 2 sitting state legislators have retained criminal defense counsel. 1 federal judge, a man who has been on the bench for 19 years and who once presided over a case that you studied in law school, is under a sealed grand jury inquiry that you know about but cannot discuss. The network you are inside is not the network you walked into that hotel conference room to meet. It is bigger, and it has resources you are only beginning to understand. And sometimes you are not certain that its interests and your interests are identical. And that uncertainty is something you carry every single day. You are still a judge. You still rule on landlord-tenant disputes and breach of contract claims and child custody modifications. You still do the work that the robe requires, cleanly, without the political architecture bleeding into it. That discipline is not just ethical, it is structural. The moment your rulings become compromised in either direction, you become something that can be discredited, and the entire architecture falls. You are the only person in this city who is simultaneously a credible judicial officer and a documented intelligence asset against the people trying to own the court system. And you cannot be both of those things if you stop being the first one. You think sometimes about the 9-year version of yourself in the public defender's office, reading Tusk's affidavit for the 4th time, the binding tape split on a stack of files nobody else wanted. You think about the decision that felt small and obvious in the moment, and was neither. You do not regret it. Regret requires an alternative, and you have stopped being able to imagine one. Your clerk knocks on your chamber's door and tells you the afternoon docket is ready. You straighten your robe, you walk out. There are 3 cases this afternoon. One is a routine civil matter, one is a contract dispute involving a construction company whose parent organization you recognized 2 months ago in a set of financial records you were not supposed to have seen. You noted it, you documented it, you said nothing. You will preside over it with perfect impartiality, and the record will be clean. And somewhere in the documentation you are building, the connection will exist for whoever eventually needs to find it. The 3rd case is new to your docket as of this morning. The defendant is a state senator. The charge is bribery. The attorney representing him is Wallace Pruitt. You sit down, the clerk calls the room to order. Everyone rises. You tell them to be seated, and you begin.